I copied an application. Did I break the law in this case?
That is a super great question.
Will Amazon go and sue?
It wasn't registered at all, even though there was an app.
Well, five miracles must happen.
No paper, you're nothing. Try to document everything. Investments in Kazakhstan are literally.
Sergey, hello. Let's figure out how it happens that sometimes an idea isn't an idea.
Hello, Mikio. Thanks for having me. I think I can answer at least some of the questions raised today on the topic. Maybe. Maybe it will even help someone create their own startup.
Their own idea.
Realize their own idea. Yes, that's key.
And my first question for you, Sergey, can we say that an idea in itself has no legal value whatsoever?
Well, to put it briefly, absolutely, yes. An idea cannot be the result of an individual's creative activity, not in any way. So, even legislation, both Kazakh law and the laws of many other countries, given the international intellectual property agreements, they all conclude that an idea itself, copyright can't apply to an idea, or rather to the idea itself. And as a result, an idea cannot be an object of creative activity. So if you think, oh, I want to do stand up, for example, suppose you haven't turned on a TV in 20 years and don't know stand up is booming, and you came up with stand up in your head. Well, you won't be able to get any protective document to, so to speak, legally secure this idea. And not because many do stand up, but because it is just an idea, meaning someone can have an idea, but someone else can execute it better. So look at Facebook, for example, probably the first social network on the internet. But today there are, well, I can't say exactly how many, but probably over a dozen. Why do you think there are so many? Precisely because an idea is not an object of copyright protection. Just for that reason, they saw the social network idea, thought, I can do it better, and they do. And, well, to be honest, even the interfaces are a little bit inspired, so to speak.
Sergey, at what point does an idea turn into that very asset?
An idea turns, that is, the way it's implemented, can become a copyright object. For example, the idea of creating some kind of platform arises. For example, let's say it's a marketplace. And so when you move from an idea to implementation and you have the first fruits of your idea's realization, that's the moment copyright arises. I want to note that copyright doesn't arise at the moment of its registration with the National Institute of Intellectual Property. Well, if we're talking about Kazakhstan, not at the moment of registration, but at the moment of its creation. That's important to keep in mind. So, registration, in fact, is just like an additional step toward protecting intellectual property. For example, how they used to do it in the analog era, so to speak, authors of certain books often did it this way. When a person wrote a book, they'd make a copy of their manuscript and send it to themselves by registered mail to their very own address. Yes, you'll see what I mean in a moment. And when that mail arrives, they don't open the envelope and they put that envelope away, and it sits there like a backup copy for humanity. Well, I mean, as a backup copy, you see. And at the moment when, if someone steals that book from them, for example, and publishes it, they can bring the documents showing the mail was sent, first of all, and the envelope itself, that it's sealed, that's the important part, to court. In court, that envelope will be opened, well, in the event of a dispute, and then the texts will be compared. Sending it to yourself by registered mail allows you to record the date of creation so that there's less room for speculation. And in general, it's actually quite difficult to prove at what point you invented something. Now, in the digital age, it seems a bit easier because there's file metadata that tells you the file's creation date and the date it was last edited. You can still manage somehow, but that's how they used to do it.
And did they send it anonymously or what?
No, not anonymously.
You can see that John sent it to John.
Yes, that doesn't interfere at all. What matters here is the fact that the original manuscript will be sealed, and we can precisely determine the date at which it was sealed. And it would be strange, for example, if I sent this manuscript on April 15th, 2026, let's say, to myself, but I don't publish it until September, for instance.
So what's the problem?
And in September, well, no, in September or say in August, you somehow, maybe you're my friend, and I share this manuscript with you so you can give me feedback, for example. You read it, pass it off as your own work, and in August, for example, you publish it before I do. And so, in order to prove that it's my manuscript, I'll say, look, I sent it back on April 16th and he only started publishing it in August.
Publishing it.
So I have a copy.
Wait a second, did I get this right? That if I wrote a manuscript, sent it to myself, but let's say I'm not in the mood to publish it. Years go by and someone else publishes it. I say, look, I've already done this. I sent it to myself. See?
Yes, that's proof of the moment of creation. Well, it would be strange if a unique work
Uh-huh.
by a person who plagiarized the result of creative thought, let's say, an object of intellectual property. He says, I invented it and publishes it, say, in August, but he didn't mail the manuscript to himself for obvious reasons, since he can't. So he might claim that he created it even before April, but I'll be able to prove that by April I had already created this work. And it's very strange that someone publishes the work after me, claiming it's theirs, when I have the original text of the manuscript.
That's interesting.
That's how they used to do it. Now, in the digital age, in Kazakhstan, it's no problem at all to get a copyright certificate. That is, it's done without even visiting the Intellectual Property Institute in person. Everything is submitted online through the Institute's portal using a digital signature, and protection certificates are issued.
So, what's the main mistake people make? Those who are passionate about a startup idea or just any idea, besides failing to record the fact of the idea.
Well, look, the idea itself needs to be turned into an object of intellectual property that is given some form. An idea on its own is not considered a result of creative thought. So, if you have an idea, you need to move to its implementation immediately. And if you shared this idea somewhere and someone else implemented it before you, you're unlikely to be able to make any claims against them, simply because an idea cannot be protected by law as an object of intellectual property. So, keep all your ideas to yourself until the moment of first implementation. And when you do the first implementation, get it. Protection documents, whether they're patents or copyright certificates, and only after that should you talk about the idea. Yeah,
In your practice, what are the most common conflicts about? Is it copyright or something else?
actually, in my practice, specifically in the Republic of Kazakhstan, copyright conflicts almost never arise.
Uh,
Yeah, I think it's because it's just not very well developed here. Although it's getting stronger now, a new law was recently passed to protect the interests of exclusive rights holders for, well, this mostly concerns our performers.
uh,
For example, about 6 months ago, banquet halls were all receiving some kind of notices. I don't remember from which company, which supposedly handles protection, exclusive rights, and in general,
music, right?
yes, yes! They were sending out mass claims about alleged illegal use,
And how did it end?
including the banquet hall. Well, in my case, I replied that their claim was based on the fact that it was a public performance as part of conducting commercial activity. But the banquet hall, which, as you know, was the party whose interests I was representing in this particular matter, essentially just rented out the space for the event, nothing more, nothing less. In other words, their involvement was limited strictly to providing the venue itself.
Mm-hmm. Yeah.
And everything else was done by the people celebrating the wedding. In this case, holding an event and hiring a DJ. And in fact, it's not a public performance because the circle of people there's a regulatory ruling by the Supreme Court stating that listening to or playing intellectual property within a family circle is not a public performance. Well, family members are close relatives, so to speak.
And there could be 200 of them.
Yes, and during a wedding, it's also unclear who's there, close relatives or not. Our kudalar, sons in law, mothers in law, and so on. They aren't considered close relatives. And that's why the Supreme Court provides a clarification that the nature of the event must be considered nonetheless. Playback during some family celebration, or conversely, a family, funerals, to be blunt, because it gets absurd if, for example, in the traditions of some people, there's the playing of a funeral march during a funeral.
Uh-huh.
Is the person who currently holds the rights to that funeral march going to demand payment for public performance at every funeral?
Well, yeah.
Of course, if you dig deeper, it's clear that the funeral march, as intellectual property, has already entered the public domain due to the time passed, more than 75 years since its first publication. But still. And therefore, it's not. That's how we responded to that claim, basically. We said it was played, first of all, by the people who were celebrating.
And they're all relatives anyway.
Well, yeah, we made a reference. Overall, there wasn't any follow up letter, and I suspect they were just sending them out to find out the registration details of the banquet hall owners in the reply. Because in the reply, you basically provide your BIN or IIN, which allows them to pull up information on you. You can't see from the sign who owns the banquet hall or who's running it, so to speak.
And plus, I'll jump in for a second. It turns out that this way they could just collect a database, right? Meaning, being in Astana or Karangada themselves, they could just send all this out. Just send it. And then the reply comes and they're like, aha,
Yes, yeah.
we have a CRM with them now.
Right, yeah. And in my reply, I didn't include our return info.
So it's not require?
Well, technically, by the rules of record keeping, you're supposed to, but I just ignored that requirement. There's no real serious liability for it anyway. But I was afraid they were just gathering registration data so they could file a lawsuit in court. Well, there are rules and requirements for filing a claim set by the Code of Civil Procedure, right? And providing the BIN, the registration number, is one of those mandatory requirements. Without it, they won't even accept their statement of claim. So I decided to play it safe and didn't specify who the holder was.
Makes sense.
Yeah, so they didn't get any further. I don't recall the name. I don't remember that company's name.
Me neither. I've heard it, but tell me, please, you also have extensive experience. Besides, let's say the practical side, which concerns things that we can actually touch, essentially. You also deal with IT law, and international law. So if we take fintech, for example, or just a startup, in those cases, if you say it's not about the idea, which is rare, okay, then what do you encounter most often there? Is it shares or what? Disputes.
About disputes? Again, I haven't really dealt with those, but I have dealt with the pretrial claim process. For instance, I represented a company that, at some point back in early 2026, obtained exclusive rights to sell and represent the interests of the holder of those exclusive rights, specifically for a trademark, of a famous farm. Of hair care cosmetics, if I recall correctly. Actually, I'm certain that's what it was. And we had the right to prohibit the use of that trademark, which basically meant banning its sale on various marketplaces and so on. And one famous, very famous cosmetic store was selling those products on its website. We wrote them a letter saying, look, we are the holders of these rights, and attached copies of the documents confirming that. And that famous retail brand, without even replying to our letter at all, simply removed all mentions of those cosmetics and the sales offers from their website. Similar work was also done with the Caspi store, but I can't tell you the outcome there because I stepped away from that project.
But then again, those are all, let's say, isolated cases. But what is the most common problem you encounter in IT specifically?
People's misunderstanding of where they should start. People come in with an idea, and some startup founders think, I've got an idea for, say, some kind of app, right? And I'm going to go ask for investment. Well, they don't give investments that way. You still need to make a little MVP, as many people say. Only then there are big problems for many startup founders. But now, by the way, this problem is becoming rarer. Well, about 3 years ago, maybe 4 years ago, there was a big problem with registering these copyrights, exclusive rights, and with the transfer of exclusive rights to the company name. First of all, a big problem with the transfer of exclusive rights. Secondly, because our market participants mostly don't really understand what intellectual property law is. Even when buying a product and signing a contract with a company, they don't even ask for proof of the company's right to commercial use of that product. And it often happens, well, I've come across such cases where a company offers some kind of IT solution, right, on the market, but in fact, if you dig deeper, the company doesn't even have the rights to that IT solution.
So it's that simple?
Actually, yes, everything is much simpler than it seems. It actually surprises me a lot. For example, as a lawyer, there are many lawyers representing the interests of individuals in civil courts where, generally speaking, there isn't much money and the laws are quite extensive, right? And fairly complex. While our legislation regulating intellectual property, compared to other branches of law, well, there's significantly less to learn there. And the logic is fairly simple. So I don't understand why there are so few specialists among lawyers, specifically in intellectual property law. Because, in my view, for a lawyer who understands how law works, it's just easier, seemingly. Now, my fellow lawyers who deal with intellectual property law will probably, I don't know, start throwing tomatoes at me for this, but everything is much simpler than it seems, yet harder than one would like.
So we'll find the boxes.
Yes.
Good. And another point. After all, any company is a team. Any company might even be a fragmented team, but it's primarily people. So, most often, a conflict starts in all these stories. In your experience, inside or outside of this team, of these people, is there any kind of statistics?
Statistics on the occurrence of conflict? Yes. In what sense? No, honestly, no. I actually like that about it. The IT industry, especially when there is a group of authors, people tend to reach agreements very well at the initial stage, and for the most part, at least in the cases I'm familiar with, they act in good faith regarding those agreements. But what should be done to prevent this from happening? Well, of course, all verbal agreements that are sealed with a simple gentleman's handshake must be put in writing, absolutely. Because if you have truly reached an agreement, there is no problem. Putting it on paper. But if someone starts saying, hey, we are great friends, a handshake is enough, it looks, at the very least, like that person is leaving themselves an opening for bad faith behavior that will not be penalized. So make sure all your agreements are only on paper. If the two of you actually came up with a product together, then get a copyright certificate in both names. Become co founders of the legal entities you are setting up, and transfer the exclusive rights to that company, and then the property rights to that intellectual property will be distributed according to the size of the share in the company. If you are, say, 50-50, if you split it, then the property rights to the company's assets will belong to you according to your respective shares.
A question occurred to me. I do not know why. Is there some kind of limit on the ideal number of people?
No, there is not.
I mean, you are saying here, like, if there are two of you, please formalize it. But, well, I do not know. In practice or in global practice, maybe there is an acceptable ideal number of founders. I mean, if there are 100 of them, it'll obviously be harder to resolve conflicts because the number of potential issues increases proportionally, even hypothetically.
Look, if there are 100 authors, then in order to protect every single one of them, it is recommended, of course, to list all 100 during registration. That is what I recommend.
Let's say they had a meetup, they met up. Using that, IT slang, they met up, had some coffee, and all 100 people shook hands with each other one after another. They said, it is all settled because I talked to Andre. And Andre talked to Alex. And Alex says, well, we all shook hands there, hands and all that. And in the end, a document appears with all the founders and so on and so forth. But all those individual agreements, well, they were not formalized in any way, essentially. And it turns out that in that case, it is a potentially very dangerous company.
It is potentially dangerous for the authors, specifically that the rights won't be protected. How does this work in practice? In practice, it usually happens like this. People come up with an idea. The people who have the idea, they don't have the skills to actually create some software. Well, they aren't developers. These people privately reach out to some development companies. They draw up a contract with them, an appropriate one, and then they start registering the copyright for themselves.
Those first people,
No, not the first ones, but the clients.
well, that's what I'm saying. The clients, not the developers.
Not the developers. Right. And there's actually a bit of a mistake here because, well, maybe we should have started our dialogue with this so that our viewers would understand what we're talking about. So, a brief excursion into the law. Copyrights, exclusive rights, to an object of intellectual property. Here's why I say that copyright and exclusive, because overall there are two sets of rights personal non property rights and property rights. So, these are two different categories of rights. What are personal non property rights? These are rights that are inseparable from the individual. Some of them are given to a person from the moment of birth and end with their death. For example, the right to life. And so, one of these personal non property rights is copyright. An author can't sell their copyright. At the same time, there's a set of exclusive rights, the owner's rights. That is, this set of rights includes like the right to sell, to commercialize this intellectual property object, to modify it, and so on. But the author will always be an individual. By the way, that's also a good clarification. Only an individual can be an author, but exclusive rights, ownership rights, can already be held by a legal entity. Where does this logic come from? Because a legal entity doesn't possess creative thought and cannot invent something as a subject, since a legal entity is a concept that has no reflection in the material world. That is, being a person only on paper, so to speak, but consisting in fact of a combination of specific individuals. In order for everything to work correctly, it's necessary that the author, like the actual author, not how it often happens in our practice, right, to simplify the process, but how it should be ideally. The developer or a team of developers must obtain a copyright certificate, which will specify an exhaustive list of authors. There can be specified there, well, an unlimited number.
So whether it's 1,000 or a million, well, let's say a city came up with something.
Technically, yes. Technically, yes. But obviously, cases of thousands or millions aren't even known in global practice.
Well, would you like to set a record like that?
Um,
To have a million founders, just like what you see in the Vatican, for example? Imagine that.
no, no, no. We're talking about copyright here.
Right, right.
Um, and then this copyright must be by this group of authors, or rather, not copyright, but the exclusive right, should then be sold directly to the client. And this client who had the idea, right, initially, once they've obtained all the exclusive rights, and it's important to understand here whether they get it as an individual or immediately as a legal entity. Well, there can be different variations of this, but that's how it should be in an ideal world. In practice, what happens is this a person orders some code or software from a development company, they deliver it to him turnkey, he goes and registers the copyright for it first, well, or so he thinks he's first, gets a protection document, transfers the exclusive rights to the company that's supposed to handle commercialization, or where investor money will be coming in. Well, that's probably a topic for a separate podcast, by the way, about investments in Kazakhstan. Investor money, the exclusive right is transferred to this company, and then the project starts to come alive. That's when you can start thinking about investors and inviting them in. Then your intellectual property object is sufficiently protected. But when you go to an investor without an MVP, without copyright, just with an idea, there's a fairly high probability that someone else will implement that idea.
Look, in your 13 years of practice, have you had cases where a founder came to you, for instance, and you realize that he'd lost his product but just doesn't know it yet?
Um, like actually lost it? No, there haven't been such cases. When there were such risks, yes, it happened. Well, he comes, like, we had one project. A project like that comes in, they're already selling it to some legal entities, they already have some commercialization, but at the same time, it wasn't formalized in any way at all. And there was even an app already. Everything was registered to an individual. And essentially, the LLC was selling the individual's property, even if it was their own founders. But it's wrong to do it that way. After all, they are different entities.
It's risky.
This can lead to certain problems arising, including tax issues. And basically, you don't have the right to sell, which you don't actually own. To sell it, you need to like register this asset to yourself, put it on the balance sheet, well, in accordance with the law on accounting. Right. To have it on the balance sheet, to value it at a certain amount somehow? Well, we've had to do it. Usually it's done, of course, in appraisal, such large sums. In general, quite large sums are appraised. Intellectual property objects in the form of software.
A question immediately popped into my head. About that ordered and done thing? Look, let's say a developer works for a company. In his free time, he's writing his own project. Well, suppose he has an idea. Well, he wants to do something of his own. An idea came to him on his laptop at home, after work, on a personal laptop, not even on a work one. Well, although,
Actually, it doesn't matter.
even with that, but I'll add that indeed, not every company provides a device. Okay, let's assume. So, in this case, this project, its implementation, is it his or the company's?
That's a super cool question. I'll note, a super cool question because I, well, while explaining, didn't mention this point. Basically, when a developer or author is an employee of a company, it's very important to watch out for employees, specifically on an employment contract. When we say employee, it means that between a legal entity and a physical person,
Your
official labor relations. And here it's very important that the employment contract is written correctly, specifically regarding intellectual property objects. According to the labor code, persons whose job duties include like generating some intellectual property objects, the exclusive rights to this intellectual property object created as part of the performance of job duties automatically pass to the employer. And so when you're doing some project of your own, being a developer,
at home.
at home, yes, not as part of performing a labor function, so to speak. Well, if the employer finds out about it, they might try to take away your exclusive rights to this product. From the right of implementation, and roughly speaking, take it away. Yeah, steal it, rob you.
But here, he'll be more able to drag that in if he sees that you're doing it at the workplace. Or just because he finds out about it. I mean, well, if a person does this project only at home and he just told him, yeah, about it, then in theory, he's doing it at home in non working hours. But if he does it during working hours, in theory, they can find fault, right?
Yes, yes. But here a difficulty arises. This one. How will we establish in court at what time of day this code was created?
So,
It's impossible to do.
what if I send myself something by registered mail?
That's possible.
But hear this question. It's quite broad.
Here, we need to dive into the specifics, take some concrete cases. Well, for example, it could be that a person is a developer for some IT company that maintains an existing IT project, a well known marketplace, and he's a developer. Specifically for this well known marketplace, fixing bugs that pop up on the marketplace, and adding new features to the already existing marketplace. And so, in this case, he creates his own project on the side that has nothing to do with this marketplace. Like, well, for instance, a book sharing app. Books just happen to catch my eye. For example,
Sure.
these are completely different things, right? And when a dispute arises between him and the employer, he'll say, look, My employer is the owner of this intellectual property object, and he shows like job descriptions, then what the work was, what tasks were set for him. That also has to be documented somehow, right?
Aber
And it's always documented very differently. So, colleagues, don't be shy about taking screenshots. I know you're all working remotely. Don't hesitate to take screenshots in work groups, especially on Telegram, because once they kick you out of there, you won't be able to do it. Don't be shy about doing it, especially when you're assigned a task. At least something will be able to protect you in that case. And then in court, you can calmly say, look, I am a marketplace developer. I fixed bugs. I expanded the functionality. Here's the job description that I signed. This project isn't about the marketplace at all. I did it on my own during my off work hours. And then it'll be the marketplace's job to prove that you used work time for this. And that's practically impossible.
Uh-huh.
Well, it's completely unclear to me how that can be proven. Maybe if they somehow bill and record screen time there on his computer, that's technically possible overall nowadays. And they record every day and store it somewhere every day and can prove that, look, it was work time, and show what he was doing on the computer at that moment, right? Then it's possible, yeah. But again, we're just moving into the realm of speculation. And here, there are all sorts of variables in all sorts of places. It's an incredible number of, well, assumptions can be made. But there is such a risk. This exactly that kind of risk when you, being a developer, are developing some project of your own on the side. The risk that when the employer finds out about it and they suddenly, in bad faith, want to claim the rights, there is such a risk.
And you mentioned investments, Sergey. What kind of world is that, briefly, that we all hear about? And earlier you said that startups there want to just come in, just make it happen and push and push and push. Investments. And by the way, a bit later, I'd like to ask you to clarify. One point, how should we view a startup that's already 10 or 20 years old? I mean, it's basically a company, but he says, I'm a startup.
Oh, yeah.
And for all 20 years, he's been raising investments. What kind of monster is that?
Well, we generally love doing that in Kazakhstan. Startups love doing that. A great example is the Astana Hub and the members of Astana Hub.
Uh-huh.
About investments, I'll probably start there. Yeah.
Yeah.
Investments in the Republic of Kazakhstan, it's literally enough to make you grab your head because the legislation of the Republic of Kazakhstan, the national legislation, views these venture investments, the small ones that are put into startups, I mean, a separate investment, contract isn't even considered in the legal sense at all. So it's viewed entirely as a debt. And those are, well, fundamentally different concepts. There's the concept of debt and there's the concept of investment. What is an investment? An investment is the transfer of some material assets in exchange for the promise of future profit. So you give me this much money, but then once we're profitable, you'll get this many percent of the profit indefinitely. But if we don't become profitable, the investments are lost. Often, option agreements are used with investments there. In short, investments in Kazakhstan are quite a complex thing because there's a law on investments and it's interpreted, at least by the courts, as a law regulating legal relations between large international investors in the state when these investors make injections into some major sectors of Kazakhstan's economy. So an investment of even $1 million into some startup, even though the amount seems quite large, doesn't qualify. And we had one case like that related to a court case specifically related to the recovery of the amount of this very investment. I think in 2019 or 2017 or maybe even earlier, I don't remember well, it was giving out money to its members. Those were also IT startups. It gave out a total of $31,000. And there's another interesting point. They gave part in cash. 20,000 and 11,000 they gave supposedly as 2 months of office space, broadband internet access, some consulting services, and so on. Supposedly for $11,000 over 2 months. Not a bad price, I must say, for office rent and broadband access.
For 2 months.
Internet, yeah, and for consulting services. Where that came from, I wouldn't venture to say. Let the viewers draw their own conclusions. But anyway, they filed a lawsuit to recover those $30,000 from one company, even though the contract had already expired. In our view, because there was an investment agreement and there was also an option agreement that allowed them. I should probably explain what an option is, right?
Yes, of course.
I'll probably use a quote from the law. An option is a derivative financial instrument according to which the one who gives the option, the person giving the option, sells the right to acquire it at a pre agreed price to another person. That is, for a fee, it says, you can, for example, within 3 years, buy for 300 Tang, some underlying asset. Most often, these are shares and stakes in the authorized capital. There. So, by taking money in advance for the transfer of the right, yeah, to buy at an agreed price, you sell an asset that might cost a bit more in the future, and that's how you get someone interested in buying this option. Anyway, this venture fund, GVA Alatola Fund, signed an investment agreement, an option agreement, and wrote a letter. We want to exercise the option. After that, the option agreement there was signed, I think, for 3 years, and it had already expired by then. But the investment agreement said it remains in effect until the parties fulfill their obligations under the investment and including the option agreement. And so in court, we faced this kind of problem because the fund believed that we didn't fulfill our obligations under the option because it thought our obligation under the option was to transfer the stake. But the obligation under an option is to sell the right to acquire a stake within a certain period of time at an agreed price. GVA Alatau Fund, well, didn't take that into account, and we represented two companies in court and successfully won those cases. There. GVA Alatau Funds couldn't prove its case.
A happy ending.
Yes, by the way, yeah, for viewers preparing for investments, to keep everything transparent, I recommend receiving investments for companies registered in jurisdictions with common English law.
AIFC.
Yes, in Kazakhstan, the AIFC provides such an opportunity. In there, disputes will be heard in their court, the International Arbitration Center, which handles disputes according to the legislation stipulated for the AIFC. That is, the law of the Republic of Kazakhstan effectively doesn't apply there, though it's used in some cases. That's not a hard and fast rule either. And there, this court, it hears cases based on English common law principles and much more frequently rules, for example, on the joint liability of members along with the legal entity of which they are a part. I actually had a case like that where we held someone liable through the IAC and we did so successfully. Lawyers know well that a legal entity isn't liable for its members' obligations, and vice versa. A member isn't liable for the obligations of the legal entity they belong to. Oh, and I'll add, always make sure to properly draft those safe agreements, or KISS, the famous long established forms of contracts. It's I don't want to say it's simple, but I think it's simple for a trained eye, probably. And always try to have these deals handled by a lawyer who understands this at least a little bit.
Do you know about AFSI?
What?
FSA.
No.
You know the AIFC? Maybe something else about the AIFC?
The AIFC?
Yes.
Well, what can I tell you about the AIFC? Only that English common law applies there.
We already said that.
Yes, and that there are tax preferences on dividends. Dividends aren't taxed there. And why was the AIFC created in the first place? It was created to increase Kazakhstan's investment attractiveness for foreign companies, and as the fintech engine. At one point, the AIFC became a favorite for miners, who started coming to us during a certain period from certain countries. But now, mining in Kazakhstan has effectively died out. There, But actually, some of the AIFC participants are the famous trading platforms Bybit and Binance. Here we can dive into digital assets a bit, right? So the circulation of digital assets is prohibited here in Kazakhstan, but if you do it through Bybit or Binance, which are authorized exchange platforms registered with the AIFC, then you can do it. There's a little caveat like that.
So it turns out the AIFC is like an island
An island of freedom.
of English law on the territory.
Yes, yes. And I also believe this is being done for because the AIFC is located in Astana, and there the control is much tighter from the highest levels of our government, right? Whereas locally, there can be some overreach by the executive branch. Well, there have been various cases.
And what about compliance?
What kind of compliance? Financial compliance?
The AIFC. They are also involved.
They conduct mandatory compliance when you join.
Yes, yes, yes. So it's not that simple either.
Not simple. You have to pass a commission. They don't have set time frames for when they will review it. We've had cases where they reviewed for 6 months and then issued a rejection. And those rejections are final and without explanation.
I copied an app. Like, I liked Spotify. So I wanted another Spotify. My own. Same interface. Same color. Well, okay, let's say I changed the color. The logic is the same, but I wrote the code myself. Let's say I'm just that talented. Did I break the law in this case?
It depends on which part. Look,
Well, I dreamed of making my own Spotify for chanson music.
Spotify for chanson? Okay. Look, surely from the standpoint that you use someone's idea, that's fine. The code will be compared line by line. And this is where a big mistake lies. It's actually very interesting to me because we all know that software isn't created nowadays by someone typing in every single line of code. It consists of blocks known to everyone. You download from GitHub, insert a block related to authorization, for example.
Suppose I did it from scratch.
Well, if you wrote it from scratch, the code itself will be evaluated, but you mentioned you'd have some unique design solution.
Well, suppose I just copied it completely. Yeah,
The design solution as well, but you don't use the name or the trademark.
well, Shancify, because it's chanson.
Scientify. Well, regarding the design, you might run into problems. It all depends heavily on how Spotify has those rights registered, and how they are actually registered, I don't know.
And by the way, that's a very interesting point. You're talking about how they're registered, but they might not have registered in Kazakhstan.
They might not have, but they could have registered another.
Right, so if they come after me for something,
A protective document will be valid here.
I see. This is an interesting point because our viewers and listeners who are watching and listening to our podcast right now, they might not know these nuances. So it's a very interesting point. The thing is, some people think that if I do something like in the West, it doesn't apply here. It hasn't been adopted here. Like, say, a food delivery system, or if I make drones like Amazon's and say it's mine. Amazon will just go and sue. And people tend to think that since they're not in the US, not over there, on a different continent, they have some kind of advantage or impunity, right?
Well, yeah, that's what they think. And look, they're partly right, because many intellectual property owners from over there simply don't know that you've stolen from them.
Well, unless it goes viral on the internet, right?
Yes.
And what if they find out online?
Well, here we need to look at a specific case again. It's very hard to talk hypothetically.
For example,
Let's say,
yes, Amazon delivery.
let's say, for example, Amazon delivery. Look, the very idea of delivering cargo or packages using unmanned aerial vehicles, also known as drones, is not just not new, it cannot be subject to copyright or exclusive rights, as we discussed at the beginning of our conversation. In fact, this concept has been around for quite some time, and the principles behind it are widely recognized and understood in the industry. Therefore, if you don't use technical solutions, patents, that Amazon holds a patent for, and you don't use any Amazon trademarks, you can easily set up such a delivery service. No one will stop you.
Well, say I want to create, for instance, Amazing Prime.
Well, look,
But there's also this concept here of confusingly similar marks. Basically, when you write Ababas instead of Adidas, for example, yes, intentionally using a very similar logo. You're not calling yourself Adidas, but you're counting on that brand's recognition. You can't do that.
Now, well, let's say I'm not counting on it. I just wanted to make it amazing. I mean,
Well, you'll most likely get sued.
I will?
Yes. For confusion,
And what if I call it, say, Astana Aircraft Service, Delivery Service, and put it all together, it becomes AIDS. And that's it. What can they do?
they won't do that.
Well, they will. It's an acronym. Okay, fine.
Well, again, these are all very specific details, and it's quite hard to speculate without a concrete case because, well, you need to look at the actual facts of the case to make any assumptions about the outcome of that case.
As usual, scary, very scary. If only we knew what it was. We don't know what it is.
Exactly.
According to your history, you've helped over 20 startups join Astana Hub. What do they have in common? Was there something in common? Was there some same mistake repeated over and over again? Or maybe, on the contrary, a miracle?
Well, what they have in common is legal nihilism in general. I mean, and I think all these startups were Kazakhstani, and people just don't understand how all of this is regulated. But what I like, again, about working with the industry is that these people who are in development usually trust your professionalism and advice, and they always do everything in strict accordance with the instructions.
But could you describe some general mechanism exactly how a founder signs documents with an investor and 2 years later finds out that he no longer makes any decisions in his own company?
Well, that's a bit different. That's about investments. This can happen in many different cases, but usually it's when an option agreement transfers voting shares and a certain stake that is controlling, meaning it allows for making decisions regardless of other smaller shareholders. If we're talking about shares, again, that is, if we're talking about private companies in the AIFC, if we're talking about LLCs, then here, everything is somewhat simpler, but it's actually more complicated with investment agreements. And there, you can lose control over the company through an option agreement, again, when simply the predominant majority of the authorized capital will be transferred to the investor.
So an investor's looking at a startup.
Uh-huh.
Let's say you're an investor. Well, let's say you're not the investor. Fine. What should he check in the first 15 minutes to understand if it's even worth getting into this? Like whether he needs it or not? Maybe he just wanted to become a patron.
From an investor's perspective,
Yes.
I think you just need to look at the project. And if you feel in your heart that you like it, that it'll take off, then yes, invest. I can't really say. Of course, you need to conduct compliance on the company, right? That you want to invest in. Well, initially, you should like the idea and what they're doing in general, right? If you feel that you can make good money on this, why not? But after you've realized that you like it and you see the potential behind it, be sure to check all the incorporation documents, all the documents on the transfer of exclusive rights to the software to the company. What else? Well, for investors too. Our investors that exist, venture capital funds, they try to work with AIFC companies because there, the investor is better protected than in our general jurisdiction. And both the investor and the other side are better protected simply in the AIFC.
So in the end, what are the three main things he needs to see?
3. Incorporation documents and whether the exclusive rights were transferred to the company. Of course, to see the project itself, to get a direct feel for it.
Many will ask now, it's just talk enough? Or do you really need to show the product and then we'll talk?
Actually, words are never enough. But if personally you have a lot of money and someone comes to you saying, look, I don't have anything yet, but I have an idea to do something, and you, first of all, trust this person enough, well, then go ahead. But simply, I was saying that you can't rule out human understanding between people. But if you've agreed in truly good faith, what's the problem with a good faith agreement when both sides sincerely want to stick to those agreements, putting those agreements down on paper? This will save a large amount of a legal consultation costs about 50,000 teng an hour, right? In Kazakhstan, well, or
On average, across the country,
yeah, something like that. I don't actually know exactly what the average cost is. And so, what's better? To pay 50,000 teng or even 100,000 for a 2-hour consultation before you start acting? Or to pay who knows how much money, because all sorts of issues can arise. At the moment when a conflict has already arisen and you have to deal with it when it's already too late to fix anything, it's always cheaper to buy a consultation. Always cheaper. But people here don't really like doing that. Although I'm seeing a trend, at least among the clients who come to me, maybe it's partly my doing, but more and more often, people are starting to come to you specifically before any legally significant actions.
that's very good.
Yeah, good. It's good. It's good for me because I can earn money just by explaining things. And even if it's less, I'm also spending significantly less time. It's good for them. They just don't go gray the moment they see everything spiraling out of control.
What are the 5 miracles that a startup should ideally have or be able to perform for you to seriously consider investing in them?
5 miracles?
Or just, let's say, to launch a startup? What 5 universal miracles should any structure in this format adhere to?
I think it's better to talk to marketers about this.
With marketers?
Yes. It's the product. It's demand in the market.
No, from a legal standpoint, well, shouldn't some 5 miracles happen? For example, finding an investor, properly signing a contract with them.
Well, those aren't miracles.
What are they, man?
It's just work that's done properly and well. It's not a miracle, it's painstaking work. Sometimes, well, more painstaking, sometimes less so.
There are no miracles in law.
None at all. Well, sometimes they happen, of course, miracles when maybe the courts apply the law incorrectly. But those are like specific cases too. Generally there are no miracles in jurisprudence. As they say, without PA.
Somewhere out there, someone is upset.
Without a paper, you're a bug. An old Soviet saying that's still relevant today. Try to document everything. Yeah, and don't skimp on money for oral consultations with lawyers. Choose a lawyer, based on how you like them. Someone who, someone you're comfortable talking to. Never try to evaluate a lawyer, like in terms of their professionalism. You don't have the criteria for evaluation. Only another lawyer can evaluate a lawyer. This simultaneously makes the task harder, but at the same time, it relieves you of the obligation, so to speak, to evaluate the lawyer and figure out if I'm hiring a good lawyer or a bad one. How do you find a good lawyer? I don't know, honestly.
Okay, well, I have this question left. If you could send one voice message to a person who is registering their first startup tonight.
What would I tell them?
Yes.
Goals shouldn't just be ambitious, but ultra ambitious. So when you're evaluating, like, okay, I'm thinking, and you're being modest, don't be modest at all, ever. Say, we want, to reach $358 billion by next year in turnover. So just why? I can explain. Because if you want to become a member of Astana Hub, you need to show, first of all, ultra ambitious goals, and second, show how you achieve those goals. Yeah, and our trend right now, by the way, in Astana Hub is tightening quite a bit. Yeah, the acceptance process. I assume that within a couple of years, it'll be difficult altogether. Control over participants is tightening more and more. So friends, make sure to jump on the last train.
Is an idea an asset or an illusion?
An illusion.
An illusion?
An illusion of an asset.
Can you steal a startup without code?
Essentially, you just borrow someone else's idea and implement it yourself. Some might call that theft, but from a legal standpoint, it's not theft.
Who does the product truly belong to? The one who came up with it or the one who registered it?
It really all depends on exactly how it's all actually done, you know?
So it depends on who made it.
It depends on how it's documented. If the person who came up with it handed over the result of their activity to another person without recording, yes, that they invented, came up with something, and that person got the copyrights, well, there will be difficulties in proving it. Yes.
What's more dangerous, a bad product or a lack of legal force?
A lack of legal force is more dangerous.
Is it possible to lose a business, even if you're the one who created it?
Yes, it is, of course. There are tons of cases, really. Starting from corporate witting, ending with just a person's basic ignorance of how to register it. We often see how people there, the ultimate beneficiary in a company that makes him money, isn't registered at all. And we often see how they can politely tell him from here, sorry, goodbye.
When does this mine stop being the truth?
Well, when you sold it, this thing of yours, if you registered it correctly, of course, at some point.